Welcome to the deep dive. Today we're diving into something more than just a court case. It's really a window onto a massive shift in society.
Yeah, how law reflects and sometimes pushes those shifts.
Exactly. And our mission here is always to cut through that complexity, find those surprising connections, give you the real insight.
Make you the most informed person at the table, hopefully.
Right. Okay, let's unpack this. So the focus today is a huge one from South Africa's Constitutional Court, National Coalition for Gay and Lesbian Equality versus the Minister of Justice back in 1998.
A landmark decision, no question.
Absolutely. And at its core, it tackled the criminalization of, consensual sex between men.
And the ripple effects of those laws were just enormous. Devastating, really.
We're going to get into the legal nuts and bolts, the arguments, how the court reasoned it through.
And why it still matters so much today. Its lasting significance.
Okay, so first up, who was actually in the courtroom, legally speaking?
Well, you had the applicants.
Yeah.
The National Coalition for Gay and Lesbian Equality.
Which wasn't just one group, right?
No, it was an umbrella body.
Yeah.
Representing gay, lesbian, bisexual, transgender people, and I think around 70 related organizations. Plus, the South Africa Human Rights Commission joined them.
A pretty broad coalition then. And on the other side?
The state. Represented by the Minister of Justice, Minister of Safety and Security, the Attorney General, the usual respondents in a constitutional challenge like this.
Got it. And what exactly were they challenging? The High Court had already ruled on some things, right?
Yes, the Constitutional Court was confirming the High Court's findings. They were targeting several laws and practices.
Mm-hmm.
The big one was the common law crime of sodomy. An old law.
And also unnatural sexual acts.
Specifically as applied to men, yes. Another common law offense. Then there was Section 20A of the Sexual Offenses Act from 1957.
What did that do?
It criminalized certain acts between men, specifically at a party, which the law defined as more than two people being present.
Wow, okay. Anything else?
Yes, really crucial parts. Getting sodomy removed from two key pieces of legislation. Schedule 1 of the Criminal Procedure Act, the CPA,
Okay.
and the Schedule to the Security Officers Act.
Right, so multiple targets.
And what's really fascinating here is just how interconnected they all were. This wasn't about penalizing one specific act in isolation.
No.
It was a whole web, a legal framework that reached into so many aspects of life for gay men, far beyond just the bedroom.
Okay, let's dig into that, because here's where it gets really interesting.
Yeah.
The real-world impact. These weren't just words on paper.
Not at all. They had severe practical consequences.
Take that Schedule 1 inclusion in the Criminal Procedure Act. What did listing sodomy there actually mean in practice?
Well, it gave the police huge powers.
Like what kind of powers?
They could demand fingerprints, palm prints, footprints from anyone just summoned for sodomy.
Just on a summons, not even charged.
Right. And arrest powers, too. Peace officers, even ordinary citizens, could arrest someone without a warrant.
On what grounds?
Just reasonable suspicion that they'd committed sodomy.
That's incredibly broad.
It gets worse. Section 49 of the CPA at the time. It actually permitted using lethal force.
Lethal force? For sodomy?
If a suspect was fleeing and couldn't otherwise be arrested, yes. For sodomy, listed right there in Schedule 1. It's shocking to think about.
Absolutely horrifying. And the impact didn't stop there, did it?
No, it seeped into other areas. Civil liberties, livelihoods.
How so?
Bail, for instance.
Okay.
A court could refuse bail if it thought the accused was likely to commit sodomy again, based on their supposed disposition.
Judging character to deny bail.
Exactly. And surveillance, too. The state could intercept mail, tap phones for sodomy investigations. Police could set up roadblocks specifically looking for people suspected of sodomy.
It sounds incredibly invasive and economically.
Big impacts there, too. A sodomy conviction could mean losing your special pension.
Your pension?
Yes, or stop you getting one in the first place. Even surviving spouses or dependents could be denied benefits.
Wow. And the Security Officers Act, what was the effect there?
Pretty straightforward, actually. A sodomy conviction meant you were barred from registering as a security officer.
Completely prohibited.
Yep. And if you were already registered, that registration could be withdrawn. Or you could be found guilty of improper conduct. It basically locked gay men out of that profession.
So if we connect this to the bigger picture, we're talking about a system that didn't just disapprove, it actively criminalized and marginalized gay men.
Absolutely. It wasn't abstract. It was this pervasive legal net affecting their freedom, their jobs, their safety, their basic dignity. It legally constructed them as criminals, as other.
Which leads us directly into the core legal arguments, right? This all came before the court under the brand new 1996 Constitution.
Yes, a very progressive constitution with a strong Bill of Rights. The applicants argue these laws fundamentally violated that new constitutional order.
What were the key rights they focused on?
Primarily three: equality, dignity, and privacy.
Okay, let's take equality first. Section 9 of the Constitution. How did the sodomy laws violate that?
Well, the common law offense was discriminatory on its face. It criminalized consensual acts between men.
But not the same acts between a man and a woman, or between two women.
Exactly. It created a clear differentiation based purely on the sex of the participants and implicitly on sexual orientation.
And crucially, sexual orientation is listed in the Constitution, isn't it?
Yes. In Section 9.3, it's one of the specifically listed grounds of discrimination. And Section 9.5 says discrimination on a listed ground is presumed unfair.
So the burden was on the state to prove it wasn't unfair discrimination.
Precisely. A very high bar.
And what was the impact of this discrimination? Not just the legal distinction, but the real-world effect.
It was profound. It fed societal prejudice, obviously. It meant gay men were living as, quote, unapprehended felons.
That's a powerful phrase.
Isn't it? It led to stigma in jobs, housing, insurance, even child custody cases. The psychological damage was immense anxiety, guilt, depression, constant fear.
And it created vulnerabilities, too.
Definitely. Vulnerability to blackmail, police harassment, even violence. The applicants argued that as a minority group, gay men were particularly dependent on the Bill of Rights for protection against this kind of prejudice.
Okay, so that's equality. What about dignity? Section 10.
The argument was that criminalizing their intimate lives was a fundamental assault on their dignity, their inherent worth as human beings.
Well, how so?
The law itself sent a message. You are a criminal. Your relationships are illegitimate. Your identity is wrong. It built, as the court later said, insecurity and vulnerability into their lives. It was degrading.
Makes sense. And the third pillar, privacy, Section 14.
Privacy protects that sphere of personal intimacy, of autonomy, making decisions about your own life, your relationships.
Including sexual preference and conduct?
Yes. The applicants argued that a total ban on certain types of consensual adult sex in private was a clear, improper invasion of that intimate sphere.
Now, I remember reading the applicants initially weren't sure whether to lead with privacy or equality.
That's right. There was some debate. But the court, very wisely, I think, didn't see them as separate issues. It saw them as deeply connected.
Ah, okay.
This raises an important question, or rather highlights the genius of the court's approach. They didn't rank the rights. They saw how the violation of privacy deepened the inequality and how both assaulted dignity.
So infringing one made the others worse.
Exactly. It was a cumulative effect, the way these violations reinforced each other, that made the whole system so egregious. Human rights are integrated, not isolated.
Right. So faced with these arguments about fundamental rights being violated, how did the court respond? Did the state try to justify the laws?
They did, but the justification argument fell completely flat. This hinges on Section 36 of the Constitution, the limitation clause.
Which says rights aren't absolute, they can be limited.
But only if the limitation is reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom. That's the test.
And did these laws meet that test?
Not even close, according to the court. They found no valid governmental purpose for these laws at all.
None. Not public health, not public order.
No, the court was blunt. Enforcing private morality, especially morality based on prejudice or specific religious views, is not a legitimate reason for the state to limit fundamental rights in a constitutional democracy.
So personal beliefs can't dictate constitutional law.
Precisely. The court acknowledged people hold sincere religious beliefs, but stated unequivocally that those beliefs cannot influence what the Constitution dictates. The Constitution stands above that.
Powerful stuff. Did the court look beyond South Africa's borders at what other democracies were doing?
Yes, they did. They undertook quite a thorough survey of comparative law. They saw South Africa wasn't tackling this in a vacuum.
Where else had decriminalization happened?
Well, the UK, England, Wales, Scotland, and Ireland had mostly decriminalized consensual adult sodomy decades earlier, often prompted by the European Court of Human Rights. Cases like Dudgeon v. United Kingdom were influential.
Okay, who else?
Germany, fully decriminalized in '94. Australia saw most states decriminalized by the early '90s, partly pushed by a UN Human Rights Committee decision, Toonen v. Australia. New Zealand did it in '86 and banned sexual orientation discrimination. Canada decriminalized way back in '69, and their Supreme Court recognized sexual orientation as a basis for discrimination claims.
So a strong international trend towards decriminalization.
Definitely. The big outlier at the time was the U.S., with the Bowers v. Hardwick decision, which upheld sodomy laws.
Did the South African court engage with Bowers?
They mentioned it, but basically said it offered no assistance.
Why not?
Because the South African Constitution was just fundamentally different. It had explicit, strong protections for dignity, privacy, and sexual orientation equality. Protections the U.S. Constitution, as interpreted in Bowers, lacked.
So the international comparison basically strengthened their conclusion.
Yes, the court said the global trend fortifies their finding that limiting these rights in South Africa was unjustifiable, especially given South Africa's own robust constitutional text.
Okay, so summing up the decision. The Constitutional Court confirmed the High Court's ruling. All those laws were struck down.
Correct. The common law offenses of sodomy and unnatural sexual acts, Section 20A, and the inclusion of sodomy in those schedules for the CPA and Security Officers Act, all declared invalid.
Now, you mentioned earlier the issue of retrospectivity. How far back did this invalidation go?
Yes, that's a crucial detail. The Constitution gives the court power, Section 1721B, to make orders that are just and equitable. It's not automatic full retrospectivity.
So what did they decide for sodomy and Section 20A?
Those were declared invalid back to April 27, 1994.
The date the interim constitution came into force.
Exactly. But, and this is key, with a very specific condition.
Which was?
The retrospectivity only applied to consensual sexual conduct between adult males in private.
Why that limitation? Why not just invalidate all sodomy convictions back to '94?
To avoid unintentionally overturning convictions for things like male rape. The old common law definition of sodomy was broad enough to potentially cover non-consensual acts, which were obviously still serious crimes under other laws like indecent assault.
Okay. So they needed to be careful not to create a loophole for violent offenses.
Precisely. This way, anyone convicted only for consensual sodomy between adults in private after April '94 could seek to have their conviction overturned through appeal or review. It ensured proper judicial control, not just a blanket voiding of past cases.
Makes sense. What about the schedules in the CPA and the Security Officers Act? Same retrospectivity?
Not quite. While declared invalid, the court limited the retrospective effect there more cautiously.
Why?
To avoid undesirable consequences. Think about potential lawsuits against police officers or officials who acted in good faith based on the laws as they stood before the ruling.
Right. Floods of civil claims.
Potentially. So they limited that aspect. However, for the special pensions issue, people denied pensions because of a consensual sodomy conviction. The court did grant full retrospectivity. They wanted to ensure those people got the benefits they were wrongly denied.
So a tailored approach depending on the specific law and potential consequences.
Exactly. Balancing the need for justice for past wrongs with pragmatic concerns, leaving some discretion to lower courts on what was just and equitable in individual cases.
Let's step back now. Beyond the legal mechanics, what's the deeper meaning here? Justice Sachs wrote a very powerful concurring judgment, didn't he?
He did. And if we connect this to the bigger picture, Sachs really cut to the heart of it. He said the case was, only in the most technical sense, about sex acts.
What was it really about then?
It was about the status, moral citizenship, and sense of self-worth of a significant section of the community. It wasn't just punishing an act. It was punishing the person, the, quote, sodomite, for being different, for perceived deviance.
That distinction between act and identity seems critical.
Absolutely. And Sachs stressed how equality and privacy couldn't be separated here.
Yeah.
They were both violated simultaneously.
You mentioned that interconnectedness earlier.
Yes. And Sachs argued human rights are just better approached and defended in an integrated rather than a disparate fashion. An attack on privacy here was also an attack on equality and dignity.
He also had a broader view of privacy, right? Not just about being left alone.
Exactly. He saw it as the right to get on with your life, express your personality, and make fundamental decisions about your intimate relationships without penalization. It's about autonomy, about shaping your own life.
And how did dignity fit in with equality for him?
He said dignity is the motif which links and unites equality and privacy. Equality wasn't just about treating people the same. It was about addressing the scarring effect discrimination has on the dignity and self-worth of groups targeted by prejudice.
And for gay men, that scarring came from?
From invisibility, he wrote. From the tainting of desire, the prohibition of the expression of love. The law essentially told them their feelings, their relationships, their very being was shameful and wrong.
So what does this all mean? It sounds like the court was saying equality isn't about making everyone the same.
Precisely. This case shows that equality should not be confused with uniformity. In fact, uniformity can be the enemy of equality.
How so?
Because true equality means equal concern and respect across difference. It's about affirming people as they are, not forcing them into a single mold defined by the majority.
So the Constitution demands we recognize human variability.
Yes. It requires society and the law to acknowledge the variability of human beings and affirm the equal respect and concern that should be shown to all as they are.
And that changes the whole game, doesn't it?
Fundamentally, it means what is statistically normal ceases to be the basis for establishing what is legally normative. The state can have a role in morality, sure, but its moral code has to align with the Constitution's values: dignity, equality, freedom, not just impose the orthodoxies of belief systems of one group onto everyone else.
So wrapping up, the NCGLE case was truly a watershed moment for South Africa.
Absolutely. It decisively established that criminalizing private consensual same-sex acts was incompatible with the nation's new constitutional commitment to equality, dignity, and privacy.
And doing this deep dive really shows how looking closely at legal reasoning can reveal these massive shifts in thinking and the real human impact behind the legal language.
It brings the principles to life.
So a final thought for you, our listeners. This decision fundamentally embraced human difference and rejected imposed conformity as a legal standard. How might that principle that statistical normality shouldn't dictate legal norms challenge us today? Where else do we see difference meeting prejudice or exclusion? And how might this constitutional vision apply?
Something to definitely mull over.
Indeed. That's all for this deep dive. Thanks for joining us.
Until next time.